morning, everybody, and I'd just like to echo, on behalf of the university, on behalf of UCC, on behalf of Donna and Hardy, I'd just like to welcome you all here to UCC today, to UCC Library, and this rights retention, this workshop focused on rights retention, which I think is particularly timely. And I'm particularly welcome to those who've travelled far. I'm looking at you, Kate, from all the way from England, and I know people from Galway are here, people from Dublin. So, making the effort to come down here is much appreciated, because these things always work far better in person, in my view. So, it's great to have you here, and looking forward to an interesting discussion on an important area as the day continues. So, what Hardy asked me just to do, I guess what I'm going to do, I'm going to take only a few minutes for this before I hand over to Hardy. I was going to talk more about open access within UCC and the work we're undertaking in that area. I just wanted, I guess from our university perspective, where we sit with regard to the wider open research agenda. And we have a strategic plan. It has 5 goals. For the first time ever, the first goal of the university. Now, the President says the goals aren't in any kind of priority, but research and innovation is goal 1, so I'm taking it as the number 1 priority of the university, is at the top there to deliver an impactful research and innovation, that addresses global challenges, etc. But within that, then, there's a bunch of strategic approaches to how we might go about delivering on that overall goal. And again, for the first time in this particular strategic plan, we call out research culture, and we call out specifically open research, and we call out engaged research as well. I think, and it's important that we did that, because I think research culture is key, will be key, and transforming our research culture will be key to delivering on goal 1 of the strategic plan. And I think a key element, as I've just said, a key element of this research culture and that transformation of research culture, which we need to do within this institution, is embracing, I think, the whole open research agenda. And embracing open research in the fullest sense. So it's not just focusing in on, maybe easier is probably the wrong way to put it, but some elements of low-hanging fruit, you might want to call them, of open research, but also, really tackling those more challenging aspects of open research. And I think rights retention is one of those, actually, and I'll come back to that in a second. But I think those aspects of open research, they're the parts of open research that will really necessitate, I think, a change in institutional culture, and if it to be effectively delivered. Now, one area is particularly close to my heart, I guess, is the whole area of reforming our research assessment. And institutionally, we've made some positive steps in that direction, as indeed a lot of the institutions that are represented here today, in that we have signed up to the SCOIR agreement and the principles, the core principles of SCOIR around reform of research assessment and responsible use of research metrics, etc. And actually, I chair with Sally Smith, who's my equivalent up in Trinity. We chair the national chapter for Ireland. We also, myself and Sally also chair a NORF-funded project, and we're going to hear from some NORF-funded projects today from Eoin and around the whole the SCOIR project. We have an equivalent project around the whole aspect of embracing research practices the incentivization of open research practices more generally. And I think, as a project, I think that what we're trying to do there will I think help, and hopefully will help other funded projects of NORF in terms of implementing the National Open Research Action Plan. As I mentioned, I think reform of research assessment is challenging, but I think another key, really important and challenging area of open research is the whole area of rights retention, and our researchers taking control of the copyright and the ownership of their research outputs. So I think this is such an important area, and this is a particularly timely workshop. And I'm looking forward to hearing today about how we might chart a pathway to implement a pathway at a sector level within Ireland, about how we might chart a pathway to implement a rights retention framework within Ireland. And I think taking a collective approach will be absolutely essential to that right across the sector. And that's why I think having Kate here from Sheffield and the N8 partnership and what they've done and how they've sort of worked together as a group of institutions to deliver progress under the rights retention agenda will be really informative, and I think something we can learn from here in Ireland. People will be familiar with Nozick's sort of pyramid of culture change. It's just to remind me to say, that it is a pathway. It will be a long journey. As I said, there's many parallels between this and the whole area of reform of research assessment, and a lot of overlap as well. And it's going to be a long journey, and it won't be easy. And effective and meaningful culture change never is easy. But what I'm looking forward to hearing today is about the SCOIR initiative, about the work Eoin's doing around putting a legislative framework around rights retention. I think that rights retention framework, in many respects, is putting the infrastructure in place. It's making rights retention possible. Obviously, if it gets into legislation, becomes a legal requirement, that would be an amazing outcome, and in terms of making it required. But I think that bit in the middle, I think, is something. Certainly, my project, through the Aboard project, can certainly help. And by winning the hearts and minds of the wider research community about the importance of this. I sometimes do think we talk a lot to ourselves about the importance of this. I think the challenge is to get out to the wider university community, to the leadership of our university community, to the management and so on, to the kind of the highly cited researchers that dominate our funding and so on, and make them absolutely aware and get them on board around the importance of this. And I think that certainly there's a role with my project around incentivisation to be able to do that. But ultimately, I think that bit in the middle about making it easy, making it normative, making it rewarding, I think working together via the NORF-funded projects and ultimately delivering the NORF, the National Action Plan for Open Research by 2030, I think will be absolutely essential. And I think NORF have a big part to play in that. And I think and the various projects within that will be absolutely essential to delivering that, and the culture change that's going to be needed to make it happen. So I think it's an important day, and this is a timely workshop to see how we might go about charting that particular pathway. So I've got 1 minute warning there from Donna. It's beautifully illustrated, Donna, by the way, so thank you for that. So that's all I wanted to say. It's just to set the... And again, thanks to you, Donna, thanks to you, Hardy, for organising this, and thanks again for our guest speakers for coming down and sort of making us aware of this agenda and getting the ball rolling, certainly within this institution, driving this important agenda forward. So welcome, and look forward to a great day. Thank you very much.
Interaction. So welcome again from me. I'm Hardy. I'm Head of Research Services here in UCC. Before I tell you a little bit about the institutional context, I want to say thank you to the whole team, Research Services. It's really a team effort to get today and the whole week. We have a few more events happening this week, so thanks everyone. So I'm going to just very briefly tell you about the institutional context about what we're talking today. So open access publishing, and more also about some facts and figures into context, some things we've already tried, and then looking into the future, and obviously that then will lead to Eoin's talk. So to start with, just a few things about how do we actually know what we publish? I mean, this is a very fundamental question for us, which when I first arrived in the scholarly communications kind of area, I was surprised that most universities don't really know exactly what they publish, and that's due to various factors. So we here at UCC, we do have what's called a current research information system, although it doesn't really give us at the moment accurate data about publications. There's other efforts, the National Open Access Monitor, a NORF-funded project, still in pilot phase, will help us hopefully, but we're still relying on these third-party tools like Scopus. Most of you will be familiar with the database Scopus, the Elsevier, OpenAlex, which is a competitor. So just to put this into context, so how much do we publish? This is the last 10 years, and it's not only UCC, this is a few other institutions in Ireland, and you can see broadly it's going upwards, and there's probably no stopping at that for at least the immediate future. Don't know if you can see any of the numbers. It doesn't really matter that much, but it's just see, so, if we think about open access publishing, we also need to think about the overall size of our publishing output is constantly, is rising as a trend. You can clearly see the trend here. If we just look at UCC, this is the last 5 years, and you can see in blue, this is the total output and a few numbers, and in orange is how much of that is open access. And you can see the open access trend, you'd think with all the efforts we do, should actually go up and up and up, but it kind of follows the overall trend. And if we then look at the percentages, we can see, again, the last 5 years, that we started, 64% shoots up, and it's actually a bit volatile. It's also, again, it's not a straight line up. That's for us also to consider. And so you can just keep that last figure in mind. That's 67.5, so it's basically 68%. So that's what we currently use in monitoring how we're doing. We're saying the current figure is 68%. Now, if we, David alluded to our strategy, there is actually a little line in our strategy about open access, and it says more than 65% of publications are open access by 2028, and you'd think, well, given that we're already in 68, that should be doable. But also, if we then look at the National Open Action Plan that David also referred to, that says we should reach 100% by 2030, so 100% by 2030. Now, how do we get there? This is how we get there, at least in theory. This is kind of the growth rates we need in open access if we want to get anywhere near 100%. So if I look at, in a couple of years, we should be by 77% when we're currently at 68. That's a bit kind of scary, to be honest, but that's the plan, that's the vision that we're on. And some people say, oh, it's never possible. No, we don't even have to try that hard. But if you look across the landscape in Europe, and there is this Leiden ranking, which some Dutch colleagues put together. So they look at here, this is a 3-year period, and if you just rank this by open access rate, so you can see that here maybe. So well done, University of Groningen, 98%, Twente, 94%, and then there's quite a number of UK universities. So getting into the 90% figures is doable because it's already happening in other countries. So we shouldn't say, just because we are where we are, it's not possible. It is. But so how do we get there? Just to recap, most of people in this room will know there's these different paths to open access. Broadly, it's the green open access is where we have our institutional repository. It's called CORA. You have the diamond open access. A lot of talk about diamond open access, where it's neither the author nor the author doesn't pay, and so no payment. And then we have the gold open access, where payments are necessary. So these are the 3 main routes, just to keep in mind. So that means for us here at UCC, again, local context, we have CORA, that's the name of our open access repository. People obviously can use other repositories that are out there in their research areas. We have open access agreements that IRL negotiates as a consortium. So this is where, as an author, you publish, and then you get the message, oh, your APC, the costs are covered by the IRL open access agreements. And then we have this thing called, it's kind of now a technical term, APCs in the wild. So this is payments that happen outside these agreements that we in the library don't really hear much about it. So that's why they're called in the wild, because we don't really know much about it. However, so obviously this is where the payments happen. And just please don't share this widely, because I'm not sure if I'm allowed to, but this is how much we paid in the last 3 full years for these APCs, that article processing charges that researchers pay, usually using their research grants or other sources we don't really know. We can get an institutional report for that, so you can see in 3 years it's a good €1 million, and we're already on track of repeating that this year. And also this, I can then see how much we pay per the article. At the moment, we're at 2,600 per AP, typical APC. Now, all of that, you know, the routes I've outlined. So how much do they take up of our publications? So this is roughly, so you can see roughly 53% of our open access output is done by gold. Then then there's another quarter, this is hybrid gold. So, you know, most of you know what hybrid journals are. So if you pay, it's not behind a paywall. And then there's actually only a quarter of that is green. So that is either in Quora or in other repositories. So that's roughly where we are at the moment. So where does that lead us going forward? Again, 68%. Remember the trajectory we want to be on. So these are my personal thoughts here. So one is we've seen that there isn't just one path to open access, and especially not if we want to achieve 100%. These publish and read agreements, I think they're here to stay. There's a lot of criticism around them, but they also helped us grow our open access output quite a lot. And I personally believe if we want to grow beyond where we are at the moment, which is roughly in the 60 to 70%, I think most Irish institutions are there. I think the green open access, so via repositories, not paying the publishers, that needs to grow. We also know, I mean, however, there's a little however here, that pretty much most of the funders, and going forward, I'm sure it will be all funders, will not accept an embargo on open access publishing. So if you publish green open access in a repository like Quora, typically there is an embargo stretching somewhere between 6 months and 24, sometimes even 36 months. Now this will not be acceptable by the funder. So what do we do? Now this is now the drum roll, because this is where I basically hand over to the superstars who will sort this out, hopefully. So this is obviously a humorous transition to the rights retention discussion. So what's that going to do with our opportunities, the options that we have? And with this, I'm finished for the institutional context. Okay.
The bull was a hole in the ground. And I'm delighted now to be here to talk about secondary rights, copyright, open access, institutional policies, and rights retention. When we were trying to come up with a name for our bid for NORF funding, one of the group, who will remain nameless, Niamh Brennan, said that we have to have a good catchy name or we won't get any money. And I can see some people nodding from experience. And so we kicked around various, what Francis Madden told me were backronyms, until we found this one, where we managed to capture most of the things that we were on about and retrofit it to an Irish word, which one of the online dictionaries told me meant unharnessing. So, secondary rights, copyright, open access, institutional policies, and rights retention gives a SCOIR. SCOIR means unharness. The group are me, I'm a lecturer in law in Trinity, Francis Madden, Assistant Head of Library Services in TUD, Niamh Brennan, her open access opposite number in Trinity, and Kaberi Basu and Arushi Sharma, who are the two researchers who make us look good. So thank you to Francis, Niamh, Kaberi, and Arushi for doing all the work. And over the next few slides, I am going to take all the credit. So SCOIR is the Irish word for unharness, as I was leading into saying. And this project aims to unharness the power of open research. We've heard some of the things that open research can achieve, and we've heard some of the things about how we should achieve 100% open access publishing very soon. And there are all sorts of ways that the ecosystem can develop to allow that to happen. This, we hope, is one of them. We did get the funding from NORF, which is why the slides keep saying thank you very much to all of our funding, the HGA who are funding NORF. who in turn are funded by the government. So, our work is in two strands. The superhero is coming later. Francis will be talking about model open access policies in the next presentation. I am going to talk about the Copyright and Related Rights Research Outputs and Open Access Bill 2024, which is my half of the credit for the work done by Arushi and Kaberi. As you will see, we hope that it is a short bill. I am not going to read the whole thing. It is on our website, and if you have insomnia, it will be a very cure for it, but a very good cure for it. But I am going to talk about some of the key features, and this kind of presentation allows me to stress test it, because every time I mention it to various people in groups like this, something that we haven't considered comes up, and then I have to go away and work out whether I need to reconsider or leave it as it is. So, the key provision in the bill relates to Section 4. And Section 4.2a, in the case of a research output that is publicly funded in whole or in part. So everything turns on publicly funding here. We can impose obligations in respect of public funding without the European Union crashing down around our ears. We can only create suggestions in the context of other funding. So this subsection, the key operative verb is shall. The employer of the author of the research output shall make or cause to make the research output available to the public by means of an open repository. Now, there's lots of phrases in that definition that we have defined earlier on. The key point for this slide is that it's an obligation on our employers to ensure that our publicly funded research is made publicly available by means of an open repository. The next subsection considers the reality that in most circumstances there are joint authors, and in many circumstances those joint authors are in different universities. One of the questions that I was asked the last time I presented an earlier version of this was, can we impose this obligation on our co-authors in Leiden? Answer, no, because Irish legislation can only apply within the Republic, but we can impose these kind of obligations in the Republic. And our hope is that if our strategy in this bill provokes Irish legislation, that in turn might provide a guide to other jurisdictions who are looking at similar things, and also provide a guide to the European Union. I will come back to how that might happen in a little while. But for our purposes right now, an employer of an author must. If it turns out that there are joint authors, at least one of them must, and if that one does, then it removes the obligation on the others, though of course the others might decide that they want to keep their things. I mean, if I collaborate with somebody in Cork, they will want to put their open access materials on Cora, and I will want to put my open access materials on Tara. And this doesn't prevent that, in fact encourages it. Joint authors themselves, or funders, may make matters publicly available by means of an open repository. And this is important for two reasons. Either A, we might be looking at an institution that is quite small and therefore doesn't necessarily have an open access repository. I mean, it's all very well for Trinity and TUD and UCC to think in terms of their open access repositories, but lots of smaller research institutions don't necessarily have that infrastructure, but their funders might, and therefore if the funders make that available, that will also meet the obligation. So there's an obligation on employers to create a workflow which is easily satisfied in circumstances where employers already have open access repositories, or satisfied by a co-author or a funder coming in and doing that as well. Now, in the case of a research output that is publicly funded, the employer shall make it available. In the case of any other work, the author or joint author, the employer or the funder may make that work available to the public by means of an open repository. So if you have the infrastructure, the open repository, and if you have the workflow that encourages the publication of outputs, what we don't want to do is to interfere with internal political settlements around authorship and credit. So for the purposes of the legislation, we're simply taking advantage of pre-existing statutory definitions of author, but we're not trying to change any internal decisions around that. So even if you don't think you have an obligation under 4.2a, we're adding that once the repository and the workflow is there, then it can be taken advantage of across the board, where there are, say, settlements around definition of author, settlements around definition of what counts for research for various purposes internally are equally as politically fraught, and equally we don't want to get involved in destabilizing any of those political settlements. So we have a definition of research output, which you will see in a moment is capacious, but there will be places where it's over-inclusive having regard to institutions. There will be places where it's under-inclusive having regard to institutions. And we recognize that, in particular, where it's under-inclusive, some institutions will require the publication of underlying data as a research output. Some aren't there yet, and we're taking no position on that. If your institution requires it, by all means, use 4.2a. If your institution doesn't, but you want to publish it anyway, by all means use 4.2d. Here's another shall. If you're taking advantage of 4.2, then 4.3 requires that the works and their associated metadata should be interoperable, be made in an open format that complies with, and this is where a lot of our integrations with existing legislation allows us to shortcut when it comes to pointing to the fact that a lot of this work has been done in similar areas and makes it easier and more palatable for our great and good political masters who will be asking for our votes to adopt things like this. And this is one of the ones where I've left the reference in. Though the regulations to which I refer here are the access to public sector data regulations, where a lot of these kinds of decisions have already been taken at an EU level and at an Irish level, and rather than reinvent the wheel, to the extent that we can follow what they are already saying in that context and bring it across, we are. Two things about that. Those regulations also talk about publicly funded data, but don't tell us what publicly funded means. So if you want to go back to the previous slide and point out that at the top there's a reference to publicly funded and I don't have it in bold, this is because if our political masters over the last 15 years in 3 different sets of regulations haven't attempted to define publicly funded, I'm not about to fill in that particular gap. I accept that they have found it difficult, so we will too. And as a consequence, if the politicians say, what does publicly funded mean? I can look back and say, you tell me, you haven't 3 times, we're simply following your lead. So that's the first thing about those regulations. But secondly, there is quite a long definition of what constitutes an open format, in particular for open licenses, in those regulations, and there is no reason to reinvent the wheel just simply to refer across to that definition, which seems to be working reasonably well in the access to public sector data. Admittedly, the local authorities in particular have been grudging about it, but the definition is reasonably okay. And then thirdly, be made available pursuant to an open license. Sorry, there should be an open before that. That's a typo. Which shall, where possible and appropriate, be the standard license published from time to time by the Minister pursuant to paragraph 4 of Regulation 10 of the regulations. And the Minister has told us that that means Creative Commons licenses. Now, in those regulations, although they wanted things to be made available by an appropriate open license, they didn't specifically say Creative Commons, on the grounds that it wouldn't be entirely appropriate to take a foreign private sector development and refer to it in Irish national legislation. There and here, there is the space for a different license to be used, a bespoke license depending on the nature of the circumstances. But if you don't have a different license, if you don't have a bespoke license, then the Minister has issued a ministerial circular that says that should be a Creative Commons license. And so we are simply adopting the same strategy. Whatever license is adopted in the context of the access to public sector data regulations, that is the license that we will adopt here too. But again, it is an open license, so it must be made available according to an open license, where possible and appropriate. So it may be that a Creative Commons license isn't possible or appropriate, and therefore you have to come up with another open license, a bespoke one. Now, for about 2 years, the Department of, what was it called then? Public Expenditure and Reform, thought it might draft its own Irish bespoke license, and every time it tried to do something, it discovered that every decision it wanted to make was already tracked by Creative Commons. So after 2 years and a lot of time and money and expense, they decided to admit that really it was going to be a Creative Commons license, unless somebody local had a specific reason for something else. We're following the same strategy. By all means, use your Creative Commons license, whichever one is appropriate. If it turns out that you need something bespoke, by all means, draft the bespoke one. Now, a few of the clauses in the interpretation that I think I want to bring your attention to. An open repository. And we're calling it an open repository rather than an open access repository, in part because that saves a word, saves me repeating typing access every time I type this, but also because presenting to different audiences like this, a lot of people were saying open repository rather than open access repository. So stealing their good idea and applying it here is a sustainable, trusted online storage and retrieval platform where research outputs and other works, the things that this bill is about, are stored and preserved without charge to the party submitting the research output or other work. So institutions might create their own open access repositories. Third-party open access repositories might emerge from the Digital Repository of Ireland. There are currently lots of subject-specific open access services like SSRN, like Archive, and so on. And they all meet that definition of research outputs and other works stored and preserved without charge to the party submitting the research output or other work, and made available to the public free of charge. So that so far as the primary users are concerned, the researchers submitting and the researchers using, it's a free of charge service. But it's not just free of charge, sustainable, trusted online storage and retrieval platform. And then the other key definition is research outputs. And research has the definition assigned to it in the Research and Innovation Act 2024. Given that they have recently tried to define research, we thought we would just simply say, well done, we're using it, in the hope that that would make it easier for us to persuade the policymakers to adopt what we were saying. But more importantly, research outputs includes works that are produced in, and this is where it becomes a word salad, academic, educational, innovation, intellectual, research, scholarly, scientific, technical, or other similar contexts. So basically anything that counts as a research output in our kinds of contexts will be caught by that definition. And are intended by their author or joint authors primarily to further such purposes or interests. This is because work might be produced here that isn't intended to be produced for research. I think of an artist in residence, I think of a writer in residence who is working on some kind of creative work for their artistic or writing output, but they don't intend it to be a scholarly output. And the last thing we want is a writer in residence who wants to publish the great novel of the early 21st century Ireland, being forced to publish that on open access rather than being able to sell it for several million euros to a New York publishing house after a bidding war. So it's got to be, broadly speaking, academic research, etc., and intended to be that. And therefore, this will not force our artists in residence colleagues to do so, but will allow everybody else to take advantage of the workflow. It's all very well saying that institutions shall make matters available in an open repository. It's all very well saying that co-authors, other institutions, funders and so on may do so, but where you've got shall, you've got an obligation. And where you've got an obligation, what you want to do is to encourage compliance and enforcement. Speak softly, but carry a big stick. So section 6 about compliance is our speaking softly. The achievement of the obligations and rights set out in section 4, remember that was the key section, shall constitute a national policy or objective with regard to higher education and research for the purposes of section 35 of the Higher Education Authority Act 2022. Now this act is not entirely popular with my academic colleagues in Trinity, and I am sure there are other institutions where it's not entirely popular either. And one of the reasons for its unpopularity is the fact that the Higher Education Authority now has some greater potential involvement in the internal affairs of institutions. And when I'm not talking about this bill, I think that's a terrible thing. But for the purposes of this bill, the fact that the HEA can reach in and say, you've got to do this, is something I think we can take advantage of. It already claims, ownership of NORF policies because it is the primary funder of NORF, and therefore it says that the open research agenda, the open science agenda, is a very important part of its oversight and remit. All section 6.1 does is it reminds the HEA that rhetoric carries consequences, and therefore it can publish policies and rules and so on relating to open access, and encourage those policies to be followed by institutions. Sometime in the last couple of years, the government quietly made the decision that all public bodies from now on must be referred to not only in an Irish name, but in an unpronounceable Irish name. I have recently been engaging with the Media Commission, and I have found it absolutely impossible to pronounce Comisiún na Man accurately. Similarly, Taida Éireann, for some reason, just doesn't flow. But nevertheless, Research Ireland, created by the Research and Innovation Act 2024, also contains various policies that include open science and open research, and again the compliance aspect of the bill reminds the new body, which doesn't have a chief executive designate anymore, and still is in the process of being set up. But once it's set up, these are the things that it should be looking at. So, bizarrely, having regard to the objects of Taida Éireann, because that is the way it is described in the bill, but never in the Act, but having set it up as Taida Éireann, it then continues to refer to it after that as the agency, which is a bit annoying. But anyway, the agency may, in awarding funding, take into account the extent to which applications for such funding ensure the achievement of the obligations and rights set out in Section 4. So to the extent that it wants to make open science an important part of the ecosystem for which it has responsibility, this reminds it of that. I mentioned speaking softly and carrying a big stick. So if our two primary regulators / funder bodies are speaking softly, just remind them that they potentially have responsibilities in this area that can encourage compliance. Really, there's only a small stick. It's a bit bigger than a twig, but it's certainly not a big stick. The Ombudsman got responsibility for the higher education sector in the last round of amendments of the Ombudsman legislation. And this simply reminds the Ombudsman that they have that responsibility, and reminds people in institutions where the institution is not making the workflow that I mentioned in Section 4.2a of our bill available, that a complaint can be made to the Ombudsman. And the Ombudsman can, somebody in that office, if they wish, investigate the complaint, or more generally, undertake a general investigation about sectoral compliance. So those are our attempts to ensure that compliance and enforcement fits within the existing landscape. I can't imagine that there would be any appetite in government to create a whole new open access czar in government. If they do, I'm available at an unreasonable price to fill the responsibility. Now, we have a bill. The next job is to persuade the various, and I don't like this word, stakeholders, but I haven't come up with a better one. So the next job is to persuade the various stakeholders that something must be done. This is something, therefore let's do this. And we're pretty much in SCOIR trying to ensure that we are hitting as many of these boxes as possible to persuade opinion formers, opinion leaders, thought leaders, and so on across these various boards to come on board. So to the extent that you guys fall within various boxes here, please, 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 A, tell us what you think about the bill, and B, if you like it, tell other people what you think about the bill as well. Coming up to the election, the second box down on the left, government and policy-making organisations, are a particularly important focus. If we can persuade somebody to take up a short bill, then we will move from there to try and encourage everybody else to support it. This is Open Access Week, hence this event and other events in UCC. There will be an event in Trinity tomorrow, so those of you who find yourself back in Dublin tomorrow and who want to hear a different perspective on our bill and on our draft open access policies and on other matters are very welcome to join us tomorrow. Happy International Open Access Week. I should say that there are some terms of art within the scholarly community that we have not used in this bill. We have not called it rights retention. We have not engaged in any way with changing definitions in the copyright and related rights legislation. So we build on the definition of author and work in the copyright legislation, but we don't change the distribution of the rights of first ownership of copyright. It doesn't matter who has, as between the employer and the employee, the right of first ownership of copyright according to Section 23 of the Copyright and Related Rights Act 2000. All that matters is that when there is a research output, the institution has to make a workflow available. Whoever ultimately has the copyright that is being exercised on foot of the Creative Commons license to publish, the institution has to enable that. So we're not trying to change the settlements in the legislation around copyright. And therefore, we're not calling this a retained right. It may be an obligation on the institution to create a workflow, and you can switch it around and say that that is effectively a right on the part of the employee or the author, but we're not calling it that, because if we did, that would be interrupting or interfering with the settlements in sections 20 to 23 of the Copyright Act, which we don't want to do, in the same way as we don't want to change political settlements in institutions around the definition of research and author and so on. We don't want to change the political settlements around authorship and copyright in the Copyright and Related Rights Act 2000. Okay, so
I wasn't planning on saying this, but I think it's worth bearing in mind. When we were starting on this, putting together the proposal for this project, I remember I had a conversation with Niamh Brennan from Trinity as well, and she was reflecting on a conversation she had had with Eoin previously, where we talked about this, and we were talking about this idea of a sort of multi-pronged approach. So we have the draft legislation on one side, which is hoping to address the issue of achieving the action of 100% open access to research publications, but then that there were other actions that we could take that would sort of enable open access in other ways, and one of these is the policy route. And so I'm going to talk about the policy updates we've made now. And there's a little bit about rights retention in here, but maybe not as much as you might expect, but we'll come to that. So yeah, as already said, so I'm based in the library at TU Dublin, and I'm sort of Hardy's equivalent really, looking after research services, and I'm also co-lead on SCOIR. And as we said, we went through the acronym, but just to say, this talk is more about the second half of the word, so from O down. And the other thing that I also wanted to highlight as we at the start here is that I think one of the great strengths of SCOIR, and particularly when it comes to this policy piece, is that we've got a really great collaboration of partners in the project, and I hope that as well we can sort of be as representative as we can be of the different types of organisation that perform research in Ireland. So we have, so UCC are involved, we've co-led by Trinity and TU Dublin. We also have ATU and TUS from the technological university sector, we've got UL, Galway. It's great to see so many representatives as well of all these universities here. We also have a couple of funders, so we have SFI, this was now Research Ireland, and the HRB as well, and EPA, and we also have the Marine Institute as a kind of research institute as well, and funder. So I think that's a real strength of it, and what we're trying to do is to develop sort of one open access policy that can fit all of our institutions. But what is an open access policy? So I took this definition from the Canadian Association of Research Libraries. They have a really helpful policy template and toolkit that we've used hugely. But it defines an open access policy as a statement promoting the openly sharing research outputs as a means of expressing support and engagement with open access. So, it's a high-level document that sets out sort of intentions, really, and requirements. It's also worth saying open access policies are not new at all. I believe my own institution, or DIT as it was, had their first policy around 2008, I believe. I wasn't there. You know, and I think Trinity had one in about 2010 or 11. So, you know, they're not new by any stretch, and over a decade. And one of the really influential developments on this was the National Principles on Open Access Policy Statement, which I always find a very awkward title, but it came out in 2012, and it was, when we looked back at these policies, it was very clear that many institutional policies basically took those principles wholesale as their open access policy, and they persist to this day. We also had the European Union's ambition for open access by default by 2020, which has been and gone. And another big development was Plan S in 2017, which introduced several new requirements, and also several Irish funders signed up to that as well. So, you know, we've had, you know, things sort of have moved on and there's been progress, but maybe the policies aren't always kept up to date with that. Then from 2019, we've had sort of 3 major NORF reports. The framework for a transition to an open research environment in 2019, the Open Research Landscape Report in 2021, and the National Action Plan for Open Research in 2022. So that's your history lesson. And the National Action Plan for Open Research, I mean, that's sort of the funding under which this project is being supported is, you know, it's discharging the actions in the action plan. So, you know, it really is core to what we're doing. And it has a goal around addressing the lack of alignment between the various funder policies and institutional policies relating to open access. So that's one of the things we're trying to do within SCOIR, is to bring that alignment into place with a view to achieving the overall ambition of 100% open access to research publications. That's kind of the National Action Plan is sort of 3 big ambitions, one of which is around open access to research publications. So the action then was to align policies, and then if we go into that in a little bit more detail, it says that we implement open access policies that support the objectives in the framework and align with international approaches such as Plan S, and that there needs to be clear guidance and support for researchers in implementing and monitoring these policies. So again, that's very much informing our work. So, to create this policy, what did we do? We looked at the existing institutional open access policies and the ones that were publicly available and those provided by public project partners, and we analysed the content. And I'm just going to cover a bit about some of the findings that we had. And you know, for those of you working in this area, I don't think any of this will be particularly surprising, but in terms of requirements, there is a real focus on articles and conference papers as being the things that had to be made open access, and everything else was sort of encouraged. That kind of did bring in a default STEM focus of, you know, focus on the sciences as a result. We did go through all of them and check to see did any of the policies mention arts and humanities, social sciences particularly. None did. Also, so I mean, you know, based on the fact that like many of these policies hadn't been updated in quite some time, you know, I think UCC's dates from 2016, if I remember correctly. You know, that predates some of the IRL agreements, for example, which I think came in about 2020. So there's a real focus of green open access in the policies and a requirement to use repositories. They sort of a lot of them don't really acknowledge the fact that it is possible to make your work open access with a publisher. Again, Diamond Open Access Publishing doesn't feature. And they are very focused on the author's accepted version. Some also include a time frame for deposit, which is useful in terms of the mechanism of implementation, and I think also might be a bit of a hangover but a sort of something that came in from the UK environment where there's quite strict timeframes around deposit. I mentioned back at the goal around the lack of alignment between funder and institutional policies. So with Plan S, one of the big things in Plan S was embargoes are not allowed. One of our major funders, as was Science Foundation Ireland, signed up to Plan S that they don't allow embargoes. But then all of our institutional policies do allow embargoes, or else they don't mention them, so they are, by default then allowed. So that's something that we've recognised that we have to change. There's sometimes mentions of the wider policy environment. That tends to really date the policy, because you can tell what was the big thing at the time. Some do mention sort of language around, like, we encourage researchers to retain copyright of their work. Some have that. Some might have a mention around encouraging use of Creative Commons licenses. And also, certain repositories have a requirement around a particular Creative Commons license in the repository. So, there's various mentions around that, but I would say the copyright sections of policies are very, that's a real point of variation between them as well. So, what is overall clear from these findings as well is that the coverage of the policies needs to be expanded if we are going to achieve that 100% open access, because there's a lot of gaps here. So, in addition to reviewing the existing examples, we also looked at some international exemplars. So we looked at some UK examples. We definitely looked at a few of the N8 policies as well. Oh, I didn't do anything. And then we also very helpfully found a couple of sort of policy frameworks that provided us with quite a helpful structure as well. So the one from Canada, and then the Open Access Network Policy Framework as well. It's also worth saying that we don't want to throw everything out and start again. We're building on these existing policies, but just updating them to reflect the current environment and context, because that has changed. Okay, I'm going to go through the policy. Bear with me. I'm going to try and not make this really boring. So, unsurprisingly, we start out with a preamble. So committed to ensuring equitable access to scholarly information of all, irrespective of location or means, which is, one would hope, quite uncontroversial. Also provide some rationale for the policy. So obviously, there's the general, fairly well understood benefit of open access. If work is open, it can be, it maximises the reach and facilitates open dissemination. Also, most institutions, I think virtually, all universities in Ireland have signed up to NORF and the National Action Plan for Open Research, and many institutions have also signed up to other initiatives such as SCOIR, UCC and has definitely signed up to that. So the Coalition for Advancing Research Assessment, then there's also the Declaration of Research Assessment, the San Francisco one, DORA, and we're also very influenced as well by the European Union's open science policy as well. So, there are many reasons why we are doing this. It's not just a public good rationale. There is more to it as well. Then we move on to the different actions. So the actions are divided up into the actions the university has to take, and then there are some actions on the researchers as well. So depending on which side of the university you work on, I'm interested in hearing your thoughts on both of these. So obviously one of the actions the university can take is around endorsing NORF and encouraging all of its researchers to actively support and pursue open access initiatives and conduct open practice. It's also incumbent upon the university to provide an environment to support its researchers, making their research outputs openly accessible through the institutional repository, read and publish agreements, Diamond Open Access Publishing, Publisher Review, Curate platforms. Now, not every university will have all of these things, but we wanted to make it clear that, there's several aspects or several ways in which the university can support researchers in making their work open access. In addition, it's important for the university to monitor and measure compliance with the policy, because otherwise, what's the point? What is the purpose of the policy if we're not going to sort of see it as well and see how it's working? And linking in with some of the work, for example, around SCOIR, around rewards and incentives and things like that, this part of it is very important as well to change behaviour. Also looking at the kind of bigger picture part and looking at things like the National Open Access Monitor, the university has to develop it and support its systems to fit in with those things. So we have the we have to provide bibliographic metadata for inclusion and aggregation systems like OpenAir that would in turn feed into the Open Access Monitor as well. So all these things are important. Then we get on to researchers and what they have to do. So researchers are required to make their research publications immediate open access without embargo via green, gold or diamond open access routes, hence the rainbow, any colour, we don't mind, just do it. And what we've also said though is that the author's accepted manuscript or version of record must be deposited in the institutional open repository as soon as possible following acceptance for publication. Now, this speaks to some of the things that came up in the Q&A earlier. So we think that the policy kind of provides that requirement around sort of capturing things in the institutional repository. I think that's in the university's interest to capture that. The repository holds the record of the intellectual output of the university, so it is important that we capture that, because platforms aren't always that reliable. We can lose access to publications. So it's incumbent on the university to make sure that we have a copy of them. How we get them can vary. So what we're saying here is the researcher has to make their work open access. It has to go into the repository. How that happens ideally would be automated and no one has to really do very much. However, that might not always be the case depending on which publisher you're working with and everything, but that's the requirement. So we have this language here that was sort of developed by the kind of policy working group around retaining copyright. So we encourage retention of copyright to their scholarly work. It's the university. Sorry, I also meant to say we've used a shorthand here of university. The university, it won't always be a university, for example, the Marine Institute, but it's used for shorthand. So the university supports researchers' rights to retain copyright over the author's accepted manuscript and apply Creative Commons licenses. The open access version must have a Creative Commons license or other open license. Now, we have another sort of piece of work within our project that's looking at rights retention language, and Eoin has very kindly said that he will draft us some clauses that will look at implementing the legislation that he's just described. So those are forthcoming as well. Also speaking to the kind of wider open research agenda and the fair data piece, we are including in this policy a requirement to include a data availability statement, or where there is underlying data. Scope has come up already. So because of this, getting to 100% open access, we have expanded the scope. So, and it is including but not limited to journal articles, conference papers, books, book chapters, and reports. So we are expanding it out, and the not limited to piece of this as well was also looking at research data as well, that depending on the status that a particular data set might have, that we want to make sure that it can be included within this policy too. Recognising some of the challenges that might be associated with implementing this, we want to make it very clear that this policy does not restrict any researcher's choice in where they publish, that this does uphold that right, but it does also impose policy obligations on them. So, but those two sit side by side. And we also want to make clear that there are a range of support services available that, again, would vary based on the local situation. So that's the policy. This is a high-level document. We've really tried to keep it a high-level document. We are going to be doing a lot of work around guidance material, local implementation procedures. We're going to be writing up a report that sort of talks through our decisions around the inclusion of these and why we have expanded the scope and why the decisions have been made and around the choice of languages in detail. And we really do hope that this policy will be acceptable to all Irish universities and research performing organisations. Going back to that alignment piece between funders and institutions, we are also developing funder policy guidelines that are based on this policy. And so those are nearly there. They're just being discussed by the funder partners at the moment. So once we kind of have, we're pretty much there with policy. As I said, we want to include those additional clauses, but once we have those, we're putting this out for sort of a wider consultation, because while we do have this great, a great group of people within the project, we recognise that, sometimes that there are lots of different people involved and lots of different people in our university, so we want to get it out as widely as possible. So we are going to be having it open for open consultation until mid-November. So I'm hoping that like this week I'll be able to send you a link to that, and hopefully be able to circulate it to all of you who are attending today. And then the plan is that the policy and reports will be finalised by January next year. So that's where we are with the consultation, and thank you very much. I'm happy to...
Hi everyone, so welcome back for the afternoon of our day on rights retention. So I'm particularly kind of thrilled that we have a speaker from the University of Sheffield, Kate O'Neill. She will tell us, so the reason why we invited Kate is because, so in my personal history, I worked at an N8 partnership, so I was aware of what that is, because I think in Ireland the N8 partnership is maybe not so well known, so you will tell us who they are and so on. But the reason why I thought this is really interesting, because they moved jointly as a partnership on rights retention, and we hear all about it. And I thought, can we maybe watch and learn and do something similar in Ireland? Do we need to do it all kind of by us, one by one, or can we actually work as a community, really? So that's why we have Kate here telling us all about the collaborative approach of the N8 partnership. So welcome, Kate, and over to you.
Thank you. So, as Hardy said, I'm Kate from the University of Sheffield, and I'm the Scholarly Licensing Manager, which is a fabulous job title that means nothing to anyone. Essentially, I'm the head of copyright and licensing, and prior to having this job, I worked in open access for about 12 years. So I'm checking with Jen, because I used to work with her, and she knows far more about my career history than I do. But basically, so I've been in the world of open access for quite a long time. So what I'm going to talk about today is what the N8 is, about the operational partnership that we set up, then a little bit about the experiences at the University of Sheffield specifically, and then there should be some time at the end for questions. So the obvious disclaimers: I'm not a lawyer. And whilst I'm talking about the work of the N8, it's very much about my experience of the group. Because we're talking about 8 institutions, they've all got slightly different perspectives on how this worked, what did and what didn't. And so I am really speaking for me as opposed to them as a whole. And on that note, of course, any mistakes I make are mine, not theirs, because they're great. So the N8 Research Partnership, and I've taken this directly from the website, and I do have notes on this one so I don't get it wrong. But essentially, the N8, it's the 8 most research-intensive universities in the north of England. So Durham, Lancaster, Leeds, Liverpool, Manchester, Newcastle, Sheffield and York. And the N8 aims to work together on certain areas that it thinks are important, and that by working together it will have more impact than institutions doing its own. Within the UK, there is this disparity between funding that the north and the south get a lot of the times, and so this is one of the ways in which trying to harness the power of saying, the north is actually pretty damn good at what we do. It's not just the south who are doing things and the institutions that you normally might think of. So it's about promoting collaboration between each other, but also going further who we can work with. It's thinking about how to establish innovative research capabilities and the programmes of national and international prominence, again drawing attention to the Northern Powerhouse and driving economic growth, particularly in the region. So the rights retention work that was done came under the strand of research, culture and environment. And basically it was thinking about how we can work together in a way that would be hard for an individual institution to do. So the rights retention area, which is what we're going to focus on, is basically going... Sorry, stick on this slide for a bit, because the other one's very distracting. There's lots of words on it. working together on this is a good idea because, firstly, it's a good way to reassure our communities, whether that be senior leadership within the university or our academics. If you do something on your own and it's seen as a bit weird as an outlier, it can be quite threatening. Whereas when you say, actually, we're doing it with all of our mates, effectively, it's a lot easier because suddenly you're no longer the outlier. These are both our colleagues, our friends, and our competitors. And so there's an aspect of that as well. Something that is new and, well, comparatively new and definitely untested is always going to make people wary. But obviously working together means we're saying it's not radical. If we're all doing it together, it can't be that much of an outlier. There is strength in numbers, but there's also a lot of comfort. And one of the things as well was about the voice that this gave us. People are more likely within government, within the media, to listen to what the N8 say as opposed to what an individual institution says. And so when we were contacting publishers to inform them about our policy, it was very much about saying we are collectively retaining our rights. And that strength, again, of saying we collectively are standing up to you, the publishers. And yes, the media do pay more attention. So what the N8 rights retention kind of statement says, and it is just a statement, it's not an N8 policy. The policy is at the individual institutional level, but the N8 has a statement. And basically the belief that rights retention at either an individual or research group level can benefit wider society. So it comes back to what Francis was saying of we know that open access is a good thing and hopefully we don't have to, in this room, keep pushing why it's a good thing. And then this is what I was sort of saying to Eoin over lunch, because the idea is that the universities are going to support the academics. So if they find themselves in that position of my funder says this, but my publisher says this, it's all about how the institution supports them and tries to take as much of the burden and the risk as it possibly can. And the N8 is not, so I should make this clear at the start, it's not just like a library coalition. There are lots of groups within the N8. So it has its Pro-Vice-Chancellors for research, memberships from research offices, legal departments and libraries. So there's lots of groups going on here at various levels of seniority. So that's the N8. And then the Rights Retention Operational Partnership. And one thing about this is, firstly I might go into acronyms because everyone knows a librarian loves an acronym. If I do, just stop, and you don't know what it is, just stop me, please. And there are also things that we did that I think are really, really good, but it doesn't necessarily mean we did everything perfectly. And I think there are some explicit things that we could and should have done better, so that hopefully if people were thinking about working collaboratively, they can learn from our mistakes, not just the good things that we did. So we began in 2022. What had happened was the assistant directors of libraries had been tasked by Pro-Vice-Chancellors at N8 to basically make rights retention work. And then it comes down to, okay, that's what the PVCs want. The assistant librarians have come up with statements and coordinated approaches, but the actual practical, what do you do, that was down to another group that got formed. And colleagues at Manchester, we at Sheffield had actually had a chat with them, just one-on-one, and they said, do you think it might be helpful for us all to work together? Yes. Sometimes it just takes someone to actually say it. And so in early December 2022, the N8 said, yes, your rights retention operational partnership is a good idea, go ahead. But all our policies were due to go into effect from the 1st of January, so December 2022 is late. So that's the first thing going. If you learn anything from this, start early. We could have really benefited from talking more much earlier in the process. We had all done a lot of work individually. So things like looking at our intellectual property policies. What did they say? Did they need changing? But none of us were actually 100% ready. Not by a long way. The practicalities. This is something that I think really is worth mentioning, because it's a lovely idea to say let's work together, but how? There's always a lot of things, so it's like, how often do we need to meet? How often is too much? And initially we actually met once a fortnight, because we were at this crunch time of we've got a lot of things to do. One thing is, a policy can come into force on a certain date, but it's actually only really implemented later, and that's where we found ourselves. How to share documentation. I don't know the situation with Irish research institutions. Most of the ones in the UK are using Microsoft Teams. Sheffield isn't. We are a Google institution, and our laptops do not care for Microsoft Teams. But we managed to make it work. And then who are the right people to be on the group? And that was quite a crucial question. And so we came up with the idea of it should be people who sort of straddle that line between the operational and the strategic. You need to have enough knowledge about the bits, the cogs, and how they work practically. What does your repository do? But you also need to have in mind that bigger picture and understand what's going on around you and how that can impact. And how big is too big for this kind of group? It's 8 institutions. How many people are too many, but how many do you need in order to ensure that it can flow? So we went for 2 people per institution. I don't think there was a single meeting where all 16 of us were there, because people are sick, something comes up at your institution, you have another priority. Some people are more, just naturally more interested in this and vocal. And so 16, so 2 people per institution, worked quite well. But then again, with the deadline that we had, of what are our immediate priorities, what are the issues we're all facing, how do we agree on those? We came up with ideas of we could vote on them, and of course, as it turns out, we were all just basically wanting to deal with the same thing, so we didn't have to worry too much about it. So where we thought we needed to coordinate was around the legal advice. We'd all had legal advice, but there were some extra little bits that we were worried about, and everyone was in a slightly different position with the legal support they had. We talked about how we are going to contact publishers. So I haven't gone into these slides about the mechanisms of what we did, but briefly, the idea is that our intellectual property policies were all updated to say the university definitely does own the copyright. And we are asserting, as the university and copyright holder, the rights in the accepted manuscripts. We then informed publishers that this was our policy. And as I say, we go back to that slide of me saying, not a lawyer. The advice we were given was that if then a publisher that we had informed of this policy presents a copyright transfer agreement to an academic, they are inducing a breach of contract because they are knowingly doing that. And any of you who have published will know copyright transfer agreements are not a lovely form in the post where you can cross things out. It's a click box. So your ability to negotiate is minimal. So that's the legal advice that we had been given. But there were bits, and so contacting publishers, how do we do that? Then the actual workflows. And I think that comes back to the talk by Eoin earlier about saying there's an obligation for you to have a workflow in that bill, and I think that's really important. What is it that we're doing to ensure that we're not making mistakes, that we're making everything that we can openly available, and that we are minimising as much burden on our academic colleagues as possible? We also talked about advocacy and the comms, both at the individual institution level, what are we doing, what works, what doesn't, but at the N8 level, how do we want to talk about it? What is the role of the N8 versus what we're doing individually? And then monitoring the policy. What's the take-up? People opting out of the policy. I'll come on to opt-outs later, but that was a big concern of if people are saying, I don't want to be part of this policy, how are we going to manage that? What do we do? So, legal. Despite the fact that the N8 on the surface looks like a group of very homogenous institutions, we're not. We are We're very, very different. Some of our institutions have in-house legal teams. If you have one, I am very jealous. Sheffield don't. So it meant that when we were getting our legal advice, we were going to our external solicitors that we work with, and of course paying each time we went. So you're trying to be as quick and efficient, but also the people you're asking are not embedded within a university. They may not understand some of the subtleties that we were asking. And then others did have an in-house legal team, but they might not have been the most approachable, and some had really good ones that they could just go back and forth with. So those that did have the internal teams were really generous in sharing what information they could. That's not necessarily saying you could pass on the emails that you got from your legal team, but the summaries. So one question around notifying publishers. Is it enough to email them, or do you have to write to them as well? If you are writing to them, do you have to ensure that they have physically received that letter by doing it signed for? These are the little niggly legal questions where kind of going, depending on how risk-averse your senior leadership is, they may well want to know. And so we were able to share that kind of information between ourselves. And of course, when I say we, Sheffield were not really contributing much outwards in that area. We were very much the whole, oh, thank you so much for sharing with us. And then we did discuss things like institutional intellectual property policies and how they would be impacted by rights retention. As I say, Sheffield had already updated theirs. Several other institutions had as well, but some hadn't. And having found out that we had, went, should we have done? Going, well, it sort of depends what it says. But also, who does your policy cover? What does it say? Are postgraduate students expected to own their own copyright, or is the institution claiming copyright ownership of postgraduate research? Because if they do, then it means that postgraduate researchers are covered by this policy. If you don't, they're not. There's good and bad sides to both of those options, but you need to be thoughtful about it. And then one thing that sort of, again, comes back to this working together was the whole, can we all be wrong? If we've all had legal advice that basically goes, all right, this hasn't been tested in law, but we're pretty sure this is okay. If our solicitors says it, that's one thing. If Lancasters say it, that's another. When Lee's in-house legal team, you start to get the whole, actually, we've got 8 disparate groups of legal who aren't talking to each other, who've all come out with the same opinion. And that, again, is where you give the comfort to others to be able to say, this is where we've come to. And I like this phrase. This is what my colleague at, I'm going to say Leeds? I think it was John at Leeds, put, going, just because something's radical doesn't mean it isn't legal. And I think this is really important for academics to understand, going, the culture of, you write your paper, you sign your copyright transfer agreement, and we've all spent the last 10 years or so saying, you've got to make it open access, but we've got these deals, we've got this pot of money, and now we're kind of doing something else again. Going, yes, we're saying we're doing it different. Why haven't we done it before? Good question, but it's not radical. Contacting publishers. So as I say, we knew we had to inform publishers. I haven't put down here about identifying which publishers to contact. Maybe I should have done. But as Hardy said, actually finding out what you publish can be a tricky issue. So what we did is we did look in our CRIS system. Ours sounds like it's better used. So we were more confident in it. And we pulled out the top 100 publishers. So basically we are left with a long tail of, we publish 2 papers a year with this publisher, 1 paper a year with them. We picked the top 100. Other institutions chose to pick their top 50. That's totally a personal choice. Sharing publisher contact details. Edinburgh, who deserve all the credit in the world for being the ones to really lead on this, have been incredibly generous sharing the contact details they found for publishers. So a lot of the work was already done, but we have departments that they don't have. You know, they have departments we don't have. So therefore, there's always going to be some you need to find. There is massive crossover. It just made it a lot easier. And this is one where I can actually say Sheffield were very good. We did find a lot and we shared it with the others. So even though we couldn't share legal, we pulled our weight here. But then the advice as to whether physical letters are required and how should they be sent. Should it be signed for? Should it be recorded? Is it enough to just pop it in the post? Everyone took a slightly different approach to that depending on how risk averse they are. The budget for postage. I never knew this could cause so many issues in so many meetings. But if you are sending things recorded delivery to 100 publishers, many of whom are abroad, it's quite a chunk. And we're all having to do it individually. As I say, we couldn't send an N8 letter because it's related to our institutional IP policies. So Sheffield kind of just went, sure, we'll pay. Others, do you use a funder block grant? Is it eligible under that, depending on which funder it is and what rules they have? Do you have sort of like a central open access fund? All these questions. And who actually prints them and arranges the postage? Again, these are the little things that I want to raise because they take time, a lot of time. And if you're not thinking about it and you don't understand how your university's post system works, because I don't, and I can't remember the last time that I tried to post something through my institution, it's hard, apparently. And as I say, we had to do it at the institutional level. We couldn't do it at an N8 level, but we could share all the information about what was in our letters, what's our publisher list, how do we think we have to contact them. And then workflows. This again is one where we have different CRIS systems, we have different repository software, very different staffing levels. I would love to be Leeds and Manchester. They seem to have staff coming out of their eyeballs. It's a beautiful thing. But if you don't have that, you might need to be streamlining your workflows a bit more. But the benefit of the N8 was that by being able to say, we have, let's say, 2 FTE working on the repository. We have symplectic elements as our CRIS system, and we have ePrints as our repository solution. Liverpool could turn around and go, well, we have symplectic elements, we have ePrints, we are also not blessed with an abundance of staff. So it meant that I could have a conversation, just myself and Martin Wolf from Liverpool, about what we would do. And we still came up with very different workflows, but we were both able to sort of explore the ideas a bit more as to what would fit the local context. And a lot of it was sense checking. Because again, when you start to think about workflows, when you're not doing it every day yourself, you know how to do it, but you're not there. You can make assumptions, you can get things a bit wrong. And yeah, we definitely thought about a few things in a weird way until I was told by Martin, why? It's like, good question, thank you. And so that was very helpful. Advocacy and comms, and this is where the UK is in a very different position, a very different start point. The REF, the Research Excellence Framework, announced in 2014 that if you wanted your research to be assessed as part of the Research Excellence Framework, which is required for your funding, you had to make your journal articles and conference proceedings papers open access. There were embargoes, but it was all about accepted manuscripts in the repository. That's what it was focused on. So we've been giving that message since 2014. That policy came into place 1st of April 2016. Our academics have had a lot of years of depositing accepted manuscripts. So therefore, it is different. Their academic behaviour didn't have to change. So how we actually talked about advocacy with our academics, we didn't have to do it in quite the same way at all, because the main question that you get is, well, what do I need to do? Effectively, everything you've been doing up till now. Done. So we're not going for detailed change. But we did talk about, we still wanted people to know about this policy. It shouldn't be something that we're sort of sneaking through the back door and going, oh, we'll just make it work magically in the background. We want academics to be aware of what we're doing and why we're doing it. So what we talked about a lot was what works and what doesn't. What had we found at our institutions that got through to people? because I will go on to this in some slides in a minute. But as soon as we were saying in this UK context, effectively you don't have to change your behaviours, what we got was, well, why are you in my meeting? Please leave, we've got more important things to do. We're grateful you told us we don't have to do anything, but why do we care? So we had to talk about a lot of that. And then also the N8. How are the N8 going to communicate this? What has to go on our website? And how do we divvy that work up? So there's a list of FAQs on the N8 website. It can't go into how do I deposit my paper, because that's institutional. But it is, what does the policy mean? You know, what's like the legal framework? How can I check if my publisher has been informed, and we can link out to things? Most of those FAQs were relevant to our pages as well, just with a bit more personal tweaking. But it meant that we were able to write collectively these FAQs, take 2 each, and you end up with a list where you're going, they can go on the N8 website, but we've also got 16 as a bank of FAQs that we can now adapt quickly for local purposes. Little things like that really, really helped. And then monitoring the policy and opt-outs. Again, very individual, but one of the questions that came a lot was, what if people don't want to engage in this policy? Because we don't have a stick. We can sort of say funders want you to make your work open access, the ref does, but ultimately if someone doesn't want to do it, that we don't really have much we can do. So we wanted to ensure, and all of us wanted to ensure, that there was the ability for people to opt out of the policy, but opting out had to be an action. You are automatically opted in unless you tell us otherwise. And you could opt out of the policy entirely and say, I don't want to make my work open access. Or, I'm depositing it, but I want you to use my publisher's policy as on Sherpa. You could say, actually, I want to opt in the policy, but a different licence. And so we talked about what reasons might people want to opt out. Do you have a tick list that says, select your opt-out reason? And my personal feeling, which I argued for, and in the end a lot of others agreed with me, was no. Because if you have a tick box, you just pick the closest one, it's fine. Whereas if you go, it's a free text box and this free text box is mandatory, hopefully you're going to get a bit more information out of that and really understand what's going on. Should these be approved or declined? What's the capacity within an institution? Because the library is never going to be the ones who go, oh, that's not a good enough reason. So we'd have to pass it on to a faculty director of research, maybe? What if it's a postgraduate student? Does it go to, their postgraduate research lead, their supervisor? So the decision that was made was, there's no approval, no declining. For the first year of the policy, you can opt out for whatever reason you like. And that, again, was agreed, I believe, across all the institutions. I might be wrong. One of them might have gone slightly differently. But we would monitor them. And we also agreed what we would do is we would collectively monitor them to try and see what the patterns were. Are there particular faculties or particular publishers who are problematic? Is it particular career stage? What information can we gather? And Manchester, our very well-staffed colleagues, have got a great bibliometrics team who said, if you give us the information, we will be able to do the work on this to pull out the patterns. And again, yes, it's free text, but we can code it so we can come out with what the reasons are. And it was like, that would be fabulous. In the end, we didn't do it. But it's a lovely idea, and I'll come on to why we didn't do it in a bit. So, I'm now going to talk about rights retention as we implemented it at Sheffield, based on the work we did with the N8. So prior to working with the N8, so this is all the things we had to do. So we had worked with our stakeholders, I will use that word because I quite like it, but at a very senior level. So the Pro-Vice-Chancellors, research and innovation committees, faculty directors, Senate, University Executive Board, all the important people, we sort of put it in front of them. We are lucky that we have an open research advisory group that's been in existence since 2015, 14, 15?
15 or 16.
15 then, we'll split the difference, we'll say 2015. And that Open Research Advisory Group has the faculty research and innovation directors on it. So it's got senior people. So we already had that buy-in, and they were the ones who were really interested in the nitty-gritty. So when we were putting it in front of other people, it wasn't just a library policy. It was a library policy as, well, a library suggestion of policy as confirmed as being good by our Open Research Advisory Group, academics. It also, in the end, correctly, is not a library policy, it's a university policy. Because again, it's not the library telling you what to do. We are merely supporting and enabling. It's come from above. And we had to assemble the data. So I had flashbacks when looking at Hardy's slides of what's going on. Where you're going, what is your publishing profile? What is the green-gold split? Again, no diamond. Because there is diamond publishing, but it's hard and how you track it. The serials budget, how much are we actually spending on journals, on our transformative agreements? What might this mean for that? What's our APC spend? And what would be the research funder impact? So if we can say we get, so UKRI give us a block grant each year, how much can we use that to make a proportion of funded research open access? Is it enough? Because if it's not enough, then there will be an impact on this. So modelling of saying, we don't know year on year how much we're going to get from this grant. So what would that mean? What's the best case scenario? What's the worst case scenario? And then obviously the key concerns and questions of what is the legal basis? Academic freedoms. So I enjoyed the question earlier from the back about, you know, well, where do I publish? You're going, the idea of this is anywhere. Anywhere, and regardless of where it is, we can make it open access. Doesn't matter if you're funded, doesn't matter if you're a postgraduate student, doesn't matter if you're the most important person in this room or the newest postgraduate who's just had a paper accepted. You can all make it open access. What we did in terms of consulting on it was just talk to academics about the policy guidance they might need. What's missing from the policy to make you understand it? What information do you need? It wasn't about, is this a good policy? Because it had already been agreed, senior, it's a good policy. So we didn't consult with academics. The decisions we made is that the Creative Commons Attribution Licence, CC BY, would be our standard. Because that is what the majority of funders are asking for. Again, you can opt out to choose a different licence, but CC BY. And we said that the policy applied to articles submitted after the date the policy came into effect. Because we were like, once we've informed the publishers, that's when effectively we feel legally secure. So submitted after that date, fine. Another institution, who I won't name because I don't know whether they've changed their policy, said, no, we're going to do it for anything that was accepted after that date. So even though the paper had been submitted before telling the publisher this is our policy, they said, we think it's fine to do this. Again, risk levels. Including the rights retention statement on the paper. We encourage it, but it's not mandated. They're not magic words. Going, the whole point is, if you include it, great. If you don't, it doesn't matter. Because it's all about, we've informed this publisher. And I've repeated myself on there. Yeah. And then opt-outs can be for any reason. We went for that one. So the main thing on this slide is we've had 3 opt-outs. The first one was in the first 2 weeks, and the person really, really thought this policy was great. It was a conference proceeding, and they weren't dealing directly with the publisher. It was the conference organiser in the middle who said, we can't possibly accept your paper unless you agree to this, and it was short deadlines. So they've all been conference proceedings, and they've all been conference proceedings where there's been a third party in the middle. It's a bit of a pain. But I think 3 opt-outs when a policy came into force at the start of 2023 is pretty good. And this is why collectively as the N8 we didn't monitor our opt-outs, because everyone's in the same position. going, I think the last time we asked one institution was up to 8, which was, it's like everyone else was going, oh, that's quite high, isn't it? But again, we're almost 2 years in, and so we don't have enough data to be able to sort of pull anything meaningful out of it. The presence of the opt-out was what mattered. When we did talk to academics about this is our policy, this is what it is, you can opt out, that was when it was oh, okay, so you're not forcing this on me. The ability to opt out seems to matter more than actually opting out. Again, that idea of academic freedom. The academic reception we had, mostly indifference at the start, because we would go and say, here's our new policy. And it's like, what do we have to do? Everything you've been doing so far. Again, indifference. The very first presentation I gave to the very first department we spoke to, the very first question was someone who was furious. This was a terrible policy. Who on earth thought this was the right way to go? It was absolutely raging. And I was like, oh dear Lord, we've made a terrible error. That's the only one we've ever had. And speaking to others across the N8 to share this, because this was the first one, I thought I must warn them that this could happen. And no, that's it. One single instance across the N8 that I'm aware of fury. Where we did make a difference is when we stopped saying, this is the policy, put your accepted manuscript in the repository. And we said, this is our new policy, carry on with everything you're doing, but this is why we have the policy. And it's because of the inequalities. It's about having this mechanism to be able to say, we own the rights, these are ours. What does that mean? Should publishers, and not all publishers are created equal, and that's important, but the profits that some publishers are making off the back of your labour, is this okay? And by phrasing it like that, that's when we got the positive buy-in. So not what is the policy, but why is the policy? That mattered. And as I say, people were reassured by the fact we had an opt-out provision. They were reassured by the legal position of the N8, very much by the lack of work required by them. Sorry, I can't help with the fact that that is going to be different here, that there will have to be a change in attitudes. But yeah, the fact this is a collective approach, because obviously N8 good, but we will also say, and Edinburgh has been doing this, and St Andrews, and Sheffield Hallam, and now we're up to, last time I checked, 33 institutions in the UK with rights retention policies. I've had an email this morning from a colleague at another institution, a very small institution, just asking a few final questions before they launch their policy. It is spreading. So the figures. We've made 414 papers as of last Tuesday, open access through rights retention. That's around 10% of, slightly under 10% of what we publish each year. So we publish around 4,500 papers a year. 10% of them we've made open access through rights retention. 330 of those have been journal articles and 84 have been conference proceedings papers. This doesn't mean that this is, it's sort of, again, it's because the policy applies to you after you've submitted your paper. So this isn't actually really 2 years figures. If you think about the lag between submission to acceptance, it's long. So we're happy with this figure. We've got a lot of transformative agreements. We have an institutional open access fund. We have a very big UKRI grant. We are able to make a lot of things gold open access. So rights retention, we were never expecting it to be a huge, huge number. If we choose at some point to cancel a transformative agreement, that's when this will get interesting. Because we informed publishers with whom we already have agreements. We didn't think, oh, well, we've got an agreement with you, so it doesn't matter. We were like, no, we will tell all potential relevant publishers. So what this doesn't say, of course, is, and it comes back to something that was said earlier about depositing accepted manuscripts versus version of record, what matters. Our academics have become quite lazy in regards to depositing manuscripts, and rightly so, because publishing gold open access don't need to. The library goes and finds it, we put it in the repository because that's a good thing. but they've got out of the habit of depositing accepted manuscripts. So whilst we're saying it's what they're used to, they are used to it, but some of them, and quite a few, have been sliding in doing it, as I say, perfectly reasonably so. So we might want to think about what we're going to do to encourage them to do more. There is actually an N8 meeting in a few weeks. We've not had one for a while because obviously our policy is in place, has been for ages. But this is one of the things that I think we're talking about is, where are we actually at? Are we happy with the numbers? What's not being captured that should be? And what I haven't done on here, and quite deliberately so, is break down the split between green and gold. Because whilst this room, it sort of doesn't matter because there is an understanding of what's happening, there is a perception still that gold is better. That gold is what we aim for. Green is a last resort, mop it up if you can't go gold. And so when we're saying green and gold, if the green figure starts increasing, some people don't like that. And so it's easier just to talk about the general proportion of open access, regardless of split, because it doesn't matter. So where next for the N8 rights retention? We're still looking at understanding the impact and the effectiveness of our policies across the N8. So as I say, this next meeting, that's one of the things to look at. Reviewing our policies, are they actually covering everyone we want to? Because as I say, some started not covering postgraduate research students. Should they? Broadening the remit. And this is where, again, going back to talking about the bill earlier, research outputs, good. Our policies concern journal articles and conference proceedings because that's what the ref mandates, so that's why it made sense. Book chapters, because again, going back to arts and humanities and social science researchers, we don't want them to be disadvantaged. And when we're saying, you publish a lot of those, but actually our policy doesn't really deal with them, should we be broadening it out? How do we do that? And then making rights retention normal. Again, just this idea of it doesn't matter how you make it open access. It doesn't matter how you get there. There is nothing wrong with retaining your rights. Maybe you should be doing it with other things as well. Maybe with the textbook that you're publishing, you might want to keep some rights to that that allow you to have more control over various aspects. And as I said, a lot of UK institutions right now are not in the best financial positions, we'll say it that way. And so we know that there will be some institutions that will be cancelling big deals. We need to have rights retention so normalised that, say, cancelling a big deal is not seen as the end of the world because you can still publish there. Okay, again, rights retention, it's fine. It doesn't matter what we ever deal with and what we don't. You don't need to worry. You just give us your manuscript and we're taking care of everything in the background. So I've put down the rights retention membership people on here because obviously it has been very, very much a group effort. And so these people have all been fabulous. And when I first did the list, I kept coming up with 15 names and I couldn't understand why. And it's because Lucy May at Manchester is the woman who came up with the idea for the partnership, sends out all the emails organising us, and of course I was just going through looking at the email list of who she'd sent it to. And so basically everyone has been fabulous, but Lucy has really been a huge driving force in this and deserves a lot of credit. So that's that. And any questions?